Hello, I'm Judge Douglas Ginsburg, and our GAI, Global Antitrust Institute discussion today is with Assistant Attorney General Makan Delrahim, head of the Antitrust Division of the U.S. Department of Justice. Welcome, Makan, to GAI and the discussion forum.
Judge Ginsburg, thank you so much for inviting me. It's always an honor to be with you and discuss a matter of mutual interest.
It will be a pleasure. So let me just say briefly by way of introduction, it couldn't be more brief since in this community you are as well known as anyone can be. But it is coming up in September, 3 years that you will have been Assistant Attorney General. And I don't think that's a record, but I can tell you it is an impressive performance. Very few people last more than 2 years in a position like that. It takes a certain equanimity and presence of mind to persist doing a great job for as long as you have. But during that time, you focused a lot of attention, it seems to me, from the very outset of your time in office, on concerns about the misapplication or misuse of the antitrust laws to intervene in what are essentially intellectual property law disputes. So I want to ask you some things along those lines, if that's okay. Recently, indeed, just last December, you issued, the division issued jointly with the Patent and Trademark Office and the National Institute of Standards, a document called Remedies on Standards Essential Patents Subject to Voluntary FRAND Commitments, which superseded a similar, well, substantively quite different, but procedurally or topically similar statement that had been issued, I think, in 2013 by the prior administration. What is the key change in policy that you were working in this statement?
Well, thanks, Judge. It's an issue that I think is one of the more critical issues dealing with just broadly innovation policy, but competition policy. We, as you correctly stated, last December, I had the great honor to be with Director Andrei Iancu and NIST Director Undersecretary Walt Kopan to announce that policy statement. I had withdrawn from that policy statement December of 2018, so we were no longer complying or following that. What I was concerned about and what had happened was that statement of 2013 was beginning to be interpreted by practitioners and some judges and others and misapplied to suggest that injunctive relief should not be available for infringements of standard essential patents, under some public policy prong of the Supreme Court's eBay decision. And eBay was one that I was involved with, in fact, supported what the Supreme Court had ruled in applying the 4 factors. And they had said it was because injunctions, quote, may harm competition and consumers. And I thought that statement was putting its thumb on the scale of that important balance that needs to be there and not turn a contractual obligation by patent owners, who I think we have a constitutional mandate to promote, into an antitrust action with treble damages where there actually isn't harm to competition, but somehow they're seeking their statutory right to seek an injunction, and also, as part of the negotiations to try to seek the maximum royalties that they otherwise would. And it changed the balance of negotiations. And I thought it's not our job to do that. If Congress wanted to somehow rebalance that dynamic, they could certainly do that, but that's not the role of antitrust law.
Well, actually, a couple of years ago, Josh Wright and I wrote an article, and now it's a few years ago, with Taylor Owens, who's with the department now, called Enjoining Injunctions on this very topic, because it was starting to appear in a few settlements, a couple of FTC settlements, in the remedy from the Korea Fair Trade Commission, in the Qualcomm case, and cropping up in one or another place. I'm quite sympathetic to the idea that it's really an inappropriate step to enjoin or to prevent a company from seeking an injunction. It's not as if injunctions are just picked up in the grocery store. I mean, you have to qualify for it under the eBay standards. It's not a matter of just filing a piece of paper and getting it, although in Germany I think it is much easier, but not in the rest of the world. So it seems quite sensible.
And I think the Supreme Court in the eBay case, if an argument could have been made that the Federal Circuit was misapplying the statute by granting automatic injunctions as soon as they found infringement without going through the four-part test and the balancing. And I think eBay allows for that, for the proper level of balancing under the equitable doctrines that we have, and just agreeing to subject your patent to the standard setting process and agreeing to fair, reasonable, and non-discriminatory, whatever they mean, does not mean you've now given up your injunctive relief. And seeking, just the mere act of seeking injunction does not mean you violated the antitrust laws. There's a lot more to violating antitrust law than seeking your statutory right.
Well, of course, some jurisdictions backed it up from seeking to threatening to seek.
Right.
That was sufficient. But let me ask you, you're probably familiar with the European case ZTE against Huawei, in which the court basically wrote a little code of practice as to how the parties would have to proceed when they're negotiating a FRAND rate. If later on there's going to be the right to seek an injunction, I have to follow certain fairly specific procedures, making a written offer, making a claim of an infringement, making a specific offer of royalty, counter offer within a certain amount of time. All has to be done in good faith, and all of that. And I wonder if you think that has any merit in terms of a way to regularize the practice, so that when it does get to the stage of someone seeking an injunction, there's a track record for a court.
I think these are so highly specific fact patterns that I don't think our law, certainly not the antitrust laws, should dictate what the process is, because every situation could be different. There could be dynamics in patent licensing negotiations where, you may want to lower, for example, upfront licensing rates to a smaller startup who wants to enter into the market, as opposed to another license to a large incumbent that's already in there. And it's a way of really financing and arbitraging entry that we don't want to preclude by some formulaic process of how those free market negotiations occur. We should look at it holistically and see if there is anti-competitive effects.
Well, that's why it's more or less why I referred to the decision in a conference in Brussels as a second best solution, the first best having been to do nothing.
Right. Right. And again, in our system, as you well know better than most, is that we have. I think our founders were wise to have the separation of powers between our three branches of government. And really, for me, the first question is, what is appropriate for us to do in the executive branch, as opposed to the policy setting that should appropriately be done by Congress, and then and interpreted ultimately by the judicial branch. So that's a fundamental issue that we should always remember in law enforcement.
Well, that really puts me in mind of the question I was going to ask you anyway, because as an enforcement agency, the division's tools are generally tailored to saying what in the division's view violates the law. And the opportunities to do that are, of course, a function of what people are doing and what comes to light about what they're doing. It's not really something that puts the agency, any law enforcement agency, in a proactive position to say things about what doesn't violate the law. And of course, from the business perspective, that's exactly what they want to know. Not just what violates the law, particularly if it's a firm that's not keen on walking right up to the margin. They want to know, well, what doesn't violate the law? And I know you've got the business review letter procedure that's available for that, but it's very structured, tailored, narrowly, and not used all that frequently by companies. So what else can you do, and are you doing, if anything, to deal with, get an affirmative message out about what is allowable?
It's a great question, and you're right. A lot of times, law enforcement is in the business of what you shouldn't be doing. But in this area where we're dealing with significant impact on how commerce is done, I think, and also, I guess, in all other areas of the law, but specific to antitrust, I think predictability and certainty about what the rules of the road are critical to commerce. You really need that. It reminds me of an old, I forget, that old saying about what Julius Caesar used to do. He would put the edicts way up high on a pillar where folks cannot read it well, because then it's easy by the government to transgress those exact rules when people are not certain of what the rules are. And what we try to do, the business review letters, as you mentioned, is one that is in our regulations. We have been using it more frequently during this pandemic under a new procedure we announced, and we can do them in 7 days. And we've issued 3 so far that are specific to it. We've dedicated a lot of resources as required to deal with the health crisis. But the business review letter has played a role. Other mechanisms that we try to do that by providing greater transparency and where the laws are not violated are filing amicus briefs in various courts, district court, courts of appeals, and the Supreme Court, and including a couple of recent ones in foreign courts, in Austria, in Mexico, and we're looking at a few other possible ones where we will bring our expertise to the foreign jurisdictions with the hope of greater convergence where it's helpful to them.
Those in private cases?
Those were were government cases, and then we brought we filed for permission in the United Kingdom, in their equivalent to our Supreme Court, dealing with their issue of first instance on class action in antitrust case, dealing with the case is called Merrick's versus MasterCard. So that's a private case. We filed, ultimately the court did not grant us the leave to allow us to file. I published an article about it using the US's experience with class action cases. But that's the one that was a private case, but we were not permitted to participate in that one, though we tried. So business review letters, sometimes in speeches. We also have guidelines. We have the IP guidelines. We have the horizontal merger guidelines, which you're intimately familiar with. And then we're about to issue in the coming weeks, for the first time since 1984, revised vertical merger guidelines. And I'm quite excited about that. I think that it will update our guidelines with a lot of the more recent thinking with economics.
I want to ask you about that, but let me just step back a second to the filings you've done in foreign jurisdictions. How were you received by the National Competition Agency when you sought permission from the courts?
So in Austria and Mexico, very well received and welcomed.
Oh.
So we checked, just as a matter of comedy, with our partners, on issues where we thought we're not just trying to be, completely officious intermeddlers in these foreign jurisdictions, but it was one where we think that, this in Austria, it dealt with cartels and damages. It had to do with a sugar cartel and whether damages, broadly outside of the borders should affect the remedies for inside of the jurisdiction. And we checked with the Austrian authority, and they very much welcomed our participation, so we did that. Same thing in Mexico, dealing with some criminal procedures and evidentiary rules in antitrust cases. That's in the process. And then, so we try to make sure that it's something we can add value and for them to consider whether they want to or not, the courts. And then the enforcers have been, so far, they've been very much pleased with what we have provided.
In the DC circuit, and probably all the circuits around the country, it's not uncommon to receive an unsolicited, of course, amicus brief with a staple to a motion that it be filed, and that can be granted or not. But that, by lodging it, as they say, puts it in before the court, whether the court grants the motion or not. Something where the local agency is not supportive, that might be yet another approach.
Yeah, we've seen, even in our Supreme Court, I think in the Intel case and a couple others where the Chinese government and the European government and Intel have filed, and they seek permission from the court, but they do not come to the Justice Department and seek our permission. I just thought, as a matter of practice and comedy, it was just good practice for us to ensure that they're on board and seek their guidance on whether or not it would be helpful for us.
Well, when you have a close working relationship, as you obviously have with COFECHA in Mexico, of course, we want to do that in fact anywhere. But then the vertical guidelines that are forthcoming. As a practical matter, it seems to me you said there were guidelines in 1984, but I haven't seen anybody advert to those guidelines for 25 years, maybe 30 years. So as a practical matter, I would say there haven't really been any functional guidelines. Why now? There have been very few. Well, I know there have always been some vertical cases that were low visibility settlements at least at the FTC, but not many and not large. Now we've had a couple of big cases in the last few years. Are you anticipating this is the wave of the future?
Well, I don't know if it's going to be a wave. It's tough to predict where the markets will be, but we're seeing more and more vertical integration because, in a lot of situations, that's actually could be pro-competitive and makes a lot of sense for businesses to try to bring that in. And we wanted to provide some greater transparency. There's a number of matters that involved vertical aspects of a transaction or just purely vertical transactions that have occurred. There was a great article speech that was done by John Sallet, I want to say November of 2016, where he outlined the various enforcement actions in vertical cases. Rarely did they reach litigation, and we had one recently in the AT&T case where that occurred. But Comcast was one where there was. Google ITA was another one, and so there's been at least a dozen that were prominent and enforcement. So sometimes the enforcement action is that the Justice Department or the Federal Trade Commission will object to the transaction, and the parties will abandon it. And there's really no precedent, no transparency of what the agencies look to. What are the efficiency considerations? What would be the harms? How do we calculate them? I don't know if we have all the economic tools at the moment, but we try to gather from the experience of a lot of these cases, some of the new economic thinking, and including the DC Circuit's AT&T case, and update these guidelines. They will be jointly issued by us. So the 1984 guidelines was just the Justice Department. On this one, it will be jointly with the Federal Trade Commission. And I think it'll add some greater transparency into the process for the business community so that they can anticipate what types of transactions would likely be fine and what types of transactions might raise some concerns for us and something for them to think, consistent with where the law is.
Well, safe harbors are very valuable for guidance and for the business community. So it sounds like maybe that's something we'll see here and there in the vertical guidance.
I don't know if there's a strict safe harbor, but there's going to be some language in there of the factors that we would consider, similar to the IP guidelines. And I think it'll be well received. We had public comment. We had issued a draft right before the pandemic, and we had a public hearing on it and a notice and comment period where we, this is not a rulemaking, so this is more about what our enforcement objectives are. But we wanted public comment, and we got a lot of great comments, and the final draft reflects a lot of the suggestions made through that process.
Well, it's good to know that this will be forthcoming soon, and that it will be issued jointly.
Yeah.
And that'll do something to allay the speculation about divergence rather than convergence within our own two agencies. Let me turn to another aspect of merger review. The recent T-Mobile Sprint case is just an example where the division, having entered into a consent decree to resolve its concerns, find that several of the states pursued the case even after that. And of course, that's what happened in Microsoft as well. After the decision of the Court of Appeals in 2001, which remanded the matter to the district court, the department settled the case, and I think it was 19 states, I think it was. Anyway, a large number of states persisted in yet a second appeal to the circuit, which of course has some collateral costs for the parties when it's prolonged like that. So here in this recent case, the states again lost their challenge in part because, as the court found, the division's negotiated resolution had resolved all the competitive concerns. So certainly raised some questions about the efficiency, let's say, of a system with multiple jurisdictions. And I don't mean the two federal agencies, although we'll discuss that too, enforcing the same antitrust laws. As you know, Judge Posner came away from his attempt to settle the Microsoft case as a mediator with the conclusion that the states ought to be put out of the business. Now, that was almost 20 years ago, and the states have been much more active in recent years than that. Indeed, this last year, I think maybe more active than ever, usually in conjunction with the department. Mm-hmm. So how is that working out, that you find yourself more often working with state attorneys general, and then from time to time having them persist when your concerns have been resolved?
So it's a great point, and it's one where I think in the coming years, in the coming decade, it's something that I think U.S. policymakers are going to need to grapple with, not only the two agencies at the federal level, but also the other 50 agencies plus at the state level, and then the international community, as antitrust becomes more and more accepted as a culture of competition. It's an important one, but it could create situations of potential conflict. I think in that case, look, a lot of times the states are great partners with us in the investigation, in prosecution. Sometimes they might have some localized expertise. I wouldn't go to the extreme that Judge Posner did, and I think at a speech at the Justice Department once where he received the Sherman Award, he called the states the barnacles on the ship of antitrust enforcement. So I wouldn't go that far, but the potential for uncertainty is a real issue that we wanted. So we made a filing with the court. I don't know if there was any precedent for that in the past, but we made a respectful filing with Judge Marrero in that state litigation where we said, look, we're the federal agency, in this case, Antitrust Division, but also the Federal Communications Commission, because it involved telecommunications licenses, have reviewed and have made a determination and have a remedy to address that. It would be our hope that there wouldn't be an inconsistent resolution with that national, where there's national benefits to consumers, and then you have, a localized remedy that then throws a wrench into the whole efficiency of a potential transaction, and there should be some deference. I was grateful that the judge looked at the transaction. He ruled against the state attorneys generals, as you know, but what he said was, and largely or partly because of the remedy the Justice Department had already imposed in that transaction, he did not find the competitive harm that the state AGs had alleged. What he also said that the judgment of the federal enforcement agencies, deserve, I believe, due deference was the word he used. So there's no deference to us that displaces the enforcement powers of the state AGs. There's Supreme Court precedent on that. But he said that our judgment deserved some due deference, which was what we asked for, and make sure that any remedies that would be, should he find a violation of the law and impose remedies, it wouldn't be inconsistent with our remedies. So in that case, I think we got to the right result, but that doesn't mean the next transaction does not, a transaction in the United States is not subjected to 50 whacks of the piñata, unfortunately. And I hope it doesn't discourage pro-competitive transactions in the marketplace or competitively neutral ones that Congress had never intended to discourage just because of the process.
Well, one of the things that seems to me rather disheartening about the settlements that then get negotiated by some of the states is that they're so often so blatantly anti-competitive. The state's interest is in retaining some facility or jobs or something of that sort, and it is in the teeth of a competitive marketplace for the states to extract, or any agency, state or federal, to extract commitments of that nature. But in my research and the writing Josh and I have done under the culture of consent title, we had an appendix full of cases in which states, usually having brought a case without the federal government involved, are settling for basically extracting rents from the merging parties. And unfortunately, the division was involved in one of the worst instances of this in the U.S. Air American Airlines merger several years ago, before your time, of course, in which the division opposed the merger and then came under pressure, so it seems from the press, from a lot of localities, governors and mayors and so on, that were trying to get special treatment for the various facilities, and the division acquiesced in that and ended up approving the merger. So that struck me as just the worst case thus far. But there are plenty of smaller, less visible ones where the states have played, I think, just a purely competitive role. Pardon me?
Right. Sometimes they try to force competition by seeking, price commitments or divestitures or cross-licensing to another, try to engineer competition. That's really not the role for enforcement officials. So I'm hoping that things will be better, but I do hope that in our system of the three branches, that the legislative branch pays appropriate attention and oversight to these issues and looks at it, what does it mean in the broader things, takes the politics out of it, looks at it substantively, and says, what makes sense, now as opposed to 120 years ago for the regime.
Well, in that respect, the department is in an unusual position among federal agencies. I think it's unusual, maybe it's just extreme, in that you have, with regard to merger control, neither Supreme Court supervision nor legislative intervention for decades and decades. Right? 45 years now since the Supreme Court heard a Section 7 case on its merits, or resolved on its merits. And it takes many decades for the Congress occasionally to intervene and change the laws. And of course, there's continuing oversight, but you're in a peculiar position, I think, in that you're kind of out there on your own with just the courts, the lower courts.
Right, right. No, it's, and, which I know you have a great article that I've, a lot of times I used to say that if you and I are not on the same page on antitrust policy, it's my duty to go back and start from page one. And you had, I think, an article about specialized courts, a system, not necessarily a specialized court, but a specialized tribunals from existing judicial officers.
Right.
And I did not think that it was necessary, but my most recent experience over the last few years here, I think has made me come around to agree with you that needs to be studied, and there's some merit to a certain level of expertise that we need for exactly that reason you mentioned. A lot of times deals, come before the agencies, they get reviewed for a period of time, and then they go before a district court judge. That takes a period of time, and then it just, by the nature of how markets work, there's not a huge appetite to wait 7 years for the application process to reach its final end through the Supreme Court just to get a merger through.
You probably do not remember a Supreme Court case called Montfort of Colorado. It was a meatpacking acquisition. Yeah. I think they were being, I don't remember the facts, whether they were the target or the acquirer, but it was filed in the Supreme Court, and it was a $15 million transaction. This was when I was Assistant Attorney General, and the lawyer for the company, for the petitioner in the court, was a close friend and classmate of mine. Previously had worked for Mr. Levy as Attorney General, Ron Carr, and he was at Morrison and Foerster. But I called Ron up and I said, Ron, I'm going to file a brief in support of your position here, but tell me one thing. Why are we in the Supreme Court on a $15 million deal? He said, local counsel forgot to provide that we get our money back if it doesn't get approved. So it was a fluke, and then of course the court resolved it on a procedural grounds.
It is, sometimes they do that, and sometimes companies might, for the precedential value, seek that. But I think this current makeup of the Supreme Court has some phenomenal legal minds that are interested in the law and economics field. So I wouldn't be surprised if they have a greater appetite. Of course, recently they saw the Apple case and the American Express case. But I wouldn't be surprised if the court picks up a merger case should one survive until that far.
Well, probably 20 years ago, 30 years ago, I asked one of the justices why they didn't take a Section 7 case, and he said, send us one. They just don't get there.
Right.
But you mentioned possibly pursuing an appeal for a matter of precedent in order to preserve or obtain a precedent. And of course, that is done in the European Union. General Electric pursued in the Honeywell matter.
Right.
Several years later, got a basically largely favorable decision from the ECJ because they were a company that had a regular flow of acquisitions and needed to resolve the matter. But I don't know. Have you seen that happen in this country?
I have not seen that now, but I could see. I could see parties, depending on what the company is. Maybe it's an entrenched, company with lots of market power or anticipation of future transactions, who might want to seek that and have some, expedited appeals that could go straight up to the Supreme Court. There's a way, within 3-4 years, you could get a case up there should somebody not like the Justice Department's and the district court's decision.
Lawyers used to tell young lawyers a long story about a client who's charged with a traffic offense, and his lawyer tells him to pay the $2, and he says it's a matter of principle, and this goes on, and eventually, he's in jail for the long term over the $2.
Yeah. Well, and I think most mergers will not survive that because I think, rational thinking would say, take the money and go somewhere else with it rather than do that. But look, the AT&T case that went up, after a pretty expedited trial in the district court in your jurisdiction, got up to the DC Circuit, and we jointly agreed to an expedited review by the DC Circuit. And that was, I thought that was done expeditiously. But had one party not been happy with, a ruling, I mean, of course, we weren't ecstatic with the ruling, but we were satisfied. And you look at the, pluses and the minuses. But for example, had we won, my guess would have been AT&T would have taken it straight up to the Supreme Court and sought certiorari to review that. And that would have been an interesting one. But that was, I think they were on third base to possibly go to the Supreme Court had it not turned out the way it ultimately did.
Well, what would you think about restoring the Antitrust Expediting Act? So three-judge district, when the government's seeking injunctive relief, three-judge district court, right of appeal to the Supreme Court.
Yeah, so when I was a Senate aide, I actually followed that model as an amendment to what became the McCain-Feingold, the Bipartisan Campaign Reform Act. And I thought it was important as a matter of policy to have quick resolution on the constitutional challenges, which we knew was going to come into that. And of course, the main legislation written, or the main decision written by Justice O'Connor in that case was went up to the court through that expedited procedure. I would be a fan of that personally, to have that, because as we engage in more debate and activity in the digital age, I think you need, one, clarity, and two, clarity as far as the rules of the road, but two, you need to be, if there's going to be a violation of the laws, you need to do that in an expeditious manner, because technology advances so far that if there's any enforcement activity in this area, by the time you investigate, litigate, go through an appeal, maybe seek an en banc review, go to the Supreme Court, that's an eternity in what we're talking about. I don't know where technology is for that to really allow the antitrust laws to be effective. So I think there's a lot of merit to bringing that back and allowing for greater review and resolution of the laws in a much more expeditious manner than we have now.
There could be some drawbacks, and there are some cases that having gone through a three-judge district court are just not ready for Supreme Court review, but the department could make that judgment. When this Microsoft came before the DC Circuit, we had a 70,000-page record and an extraordinary number of issues and some matters that just had gaps that had to be filled in. We knew the case was never going to go to the Supreme Court unless it came back the second time, which was an awesome sense of responsibility, but also sort of a drawback of having the procedures that we do have, that things take so long.
They take a long time. I think they allow for courts, for issues to percolate, for records to be full. But a lot of times it's the actual rule of law. So some of our most impressive cases have been brought up to the court on through the 12b-6 at that stage, where the courts have reviewed that, including, I think, Trinco, that was on that procedure. So relatively expedited and not the full record yet, but just to know what the law is at the moment, rather than resolution of the application of the facts there. So, and I think there's definitely some questions. Of course, there's conferences almost every week and lots of law review pages that are filled with this debate, which is what makes antitrust interesting. But it doesn't provide the business decision makers with the level of clarity on the application of the law. I think it's, there's a lot of flexibility. That's a positive, but not if there's too much room for its application.
Yeah. I think the idea of reinstituting the Expediting Act would be really interesting one to try out now in the Congress and see what happens, and maybe some refinements of it. So as you've hinted at in a couple of other contexts, we're living in a super multinational jurisdictional environment. Everyone knows well over 120 some agencies around the world, more regional agencies emerging in South America, in Africa, and of course, obviously the European Commission. So I'm wondering how this affects the division, knowing that there are these other in merger cases, these other reviews taking place. Maybe some have been resolved. In the most recent one, Sabre Faralogics, it was CMA acted after the district court in this country. How does it affect the dynamic? The chess game becomes multidimensional.
Again, I think it adds yet another element of uncertainty for deal making where you have multiple jurisdictions. I think more and more jurisdictions, as they engage in this, it highlights how important, one, transparency is of what the laws and the rules are, and that we're applying, consistent and justiciable principles of competition law that are somewhat at least clear to the parties when they engage. Just as I don't think we want in the domestic arena inconsistent results and policies and 50 whacks at the piñata, I think it would be a lot worse if you had 170 whacks of the piñata if you add the 120 jurisdictions to a major transaction. So I think it's really important. I think what is also important, especially as new jurisdictions come on board, is the principles of due process, of how do you go about doing that. One of the areas that has provided, it gives me a lot of hope for the future, is the activity in the ICN and the OECD, and you have been a great contributor to both of those multilateral fora, to allow for best practices, to learn from each other's experiences. We certainly don't have a monopoly on good practice, but we at least have, our jurisdiction, the European Commission, Canada, a lot of experience, and we know sometimes what we did wrong, and we've learned from that, and we hope a new jurisdiction does not make those same mistakes, which ultimately hurt their consumers and hurts commerce. And so a lot of dialogue has occurred, but I think it's really important that jurisdictions have defined and transparent and objective principles and rules of the road, so that there isn't, and there's also not allegations that a jurisdiction is acting against a company that might be a resident or have its headquarters in another jurisdiction, and it's done for xenophobic reasons, that is retaliatory because of trade disputes or otherwise. I think antitrust and trade law both have the same ultimate goal of having frictionless commerce and frictionless trade, but where the trade policy is really based on a lot of negotiations to lower those barriers. Competition policy at its core is really intended for the greatest efficiencies, to allow for that commerce, because everybody benefits from that competition.
Well, on this matter of due process, and I entirely agree with the centrality of it to legitimacy and efficiency of proceedings in every jurisdiction. And I congratulate you on the great deal of effort and prolonged effort you made to get to where the ICN is now with the multilateral framework for procedures. But as you may know, the Global Antitrust Institute, here we do programs teaching mostly economics, both to judges who hear competition cases and to agency staff from around the world. And we recently started doing some sort of mock, I wouldn't say mock proceedings, but taking staff through the stages of an investigation and asking how they handle various things. And all I can tell you from our experience is that the rules don't, the rules can't function at the level of granularity that actually arises in each individual investigation. A letter comes in from another government agency, allegations are made by rival firms, and how these things are going to be handled correctly is very important, and it's very easy without forethought or prior experience to mishandle them in some way. So I don't think there's any substitute, frankly, for exchange programs in which I know the FTC and the division are bringing, well, the FTC I think does more because they can have non-citizens even on the payroll, but working with staff from other agencies so that they see the kinds of things that arise and the sensitivity that due process really requires. So the more you can do along those lines of actual application jointly, I think the better.
Well, I think, what you have done personally, but Josh and Bruce and others at the Global Antitrust Institute, it's a critical element of what will ultimately be a global community of antitrust enforcement, is to making sure that the judges and prosecutors in foreign jurisdictions have that. I would hope that there would be either through the Department of Commerce or State or the Justice Department, that Congress continues to see the wisdom of perhaps providing additional funding and resources, not only to the agencies, but to outside organizations to provide that type of economic training abroad, because I think ultimately we all benefit from that. It is the residency programs are very important. We have these 2-week programs where senior officials or investigative officials from other jurisdictions come to the division and they spend time. But we also have these 6-month programs where they can really get into the nitty-gritty of an investigation. We had a couple that were had to be unfortunately canceled because of the current pandemic and the travel restraints. But we are hoping that once those restrictions are lifted, we will re-engage and do that. We've had our colleagues from the Australian Authority, from Canada, from Israel, that have come, from the European Commission, that have come and have been resident with us and almost a part of the staff. And they take that knowledge and cross-pollinate that with other jurisdictions. And I think ultimately we're all beneficiaries of it in this global community.
That's really, I didn't know you had those 6-month tours. I think that's really terrific. I hope some of the other major jurisdictions will do the same for third countries. Moving on a bit, because I know we have limited time. You have limited time. One of the innovations that you've driven through these last almost 3 years, the recent part of it actually, has been this submitting a case, well, actually a particular question to arbitration. I don't know if there's ever been a precedent for that in the division. I'm not aware of it, if there has been before you just did this. What was your thinking, and how do you think it went, and what's the potential for doing this in the future?
So, I'm a big fan of innovation policy, and I think our processes can sometimes benefit from some innovation. Look, we all know arbitration, whether it's cross-border disputes or whether it's business disputes. There's definitely a lot of benefits from arbitration. There was a transaction, and you're referring to the Novelis-Alaris merger. This dealt with aluminum manufacturers. And as we investigated that, we came to a head, and there was a dispute between the division and the parties we came down to really one dispute, which was market definition, which is, the $64 million question in most merger disputes. But that was market definition. And we've, fully admitted that if the definition of this particular market was such that steel was included, then there is no competitive harm that we could prove, and we don't have a problem. But if there was, then there was a significant price increase, and it would violate Section 7. What we were left with was either the parties abandoning the transaction, or we bring a lawsuit to litigate that. And this dealt with a lot of, regression analysis, dealing with prices and diversion by the, automobile manufacturers or customers of aluminum products. And it required some sophisticated thinking. And, you go to a generalist court, you don't know what you're going to have. There's going to be uncertainty around that. So I suggested to the counsel for the parties, in this case it was Dan Wall, who's a very experienced litigator, is would they be open to us litigating? And we had to arbitrate the matters, to submit it to arbitration and see if there was a way to do that. And I'll be totally honest, at the time, I wasn't aware of the legislation and the regulations that allowed that. I don't think there were too many people in America who might have been aware of that. This was the Administrative Dispute Resolution Act of 1996, I believe. And only through, as we were researching an agreement between us and the parties to enter into arbitration, we came across this legislation and also Department of Justice regulations relating to this that were issued back by Attorney General Janet Reno and my predecessor, your successor, Ann Bingaman, who was the head of the Antitrust Division at the time, who occupied this chair. And so we were looking at issues dealing with discovery and the process and the compulsory process to third parties for the arbitration. And we came across this. In fact, it was Taylor, your former clerk, Owings, who was my front office counsel, who researched that and came up with that. So we were very grateful. And so we then looked at the law, looked at the powers it provided, the parties agreed. And there was a lot of efficiencies, I thought. One, we were able to have some certainty of how long it would take. We, by agreement, agreed that, there's going to be a certain period of discovery process. Of course, you could, agree to it in a CMO and submit it to a district court judge for some of those. But we also agreed that, there wouldn't be any post-trial briefing unless the arbitrator demanded it. We also agreed to a process by which we would pick the arbitrator. And in that case, we both came upon and agreed to a single arbitrator who was a very experienced litigator in this field and a former director of the Bureau of Competition of the FTC, Kevin Arquette. And he was available and not conflicted to do that. So a lot of things came together for us, but it created not only efficiency for the division in resources, taxpayer resources we would use, but we knew there was going to be a terminal period. We had agreed that, there's going to be 10 days for the arbitration. There would be a ruling within 10 days or 14 days, I forget the exact time, by agreement of the parties, that it wouldn't be longer than 5 pages. So it allowed for a very focused analysis decision. I think both sides, we ended up being the arbitrator ruled for us, but I think both sides appreciated that because it also provided certainty. We knew what the remedy was going to be. If we were going to win, we would get a divestiture of a plant that we had required up front that the parties were not agreeing to. But if we lost, they would. And in the meantime, we allowed the transaction to close and allow that plant to be held, in a hold separate status, so it wouldn't combine until at the end of the arbitration. And I think the parties benefited from that because they had certainty. It wasn't going to take a year for a judge to rule and, unlimited proceedings. And then we benefited from the efficiency. They benefited from the efficiency and the certainty. And I think everybody who saw the 5-page opinion saw how well-reasoned and detailed it was. And I think the process was a success. We learned a lot through that process, the extent and use of experts, the numbers of deposition, a lot of things where, you might want to preserve those options if you're litigating to a generalist judge. But if you have an expert in law and economics in this area who's been both an enforcer and a defendant, you can do away with that. And so I think it could even be more efficient in the future. And it is my hope that, should the circumstances arise, we would use it again.
Well, as you said, applied, the market definition is so often the conclusive issue. And even if it's not, shrinking its resolution, as you've done in this Alaris Novellis case, even if it then means going on to litigate something else, would still be a vast improvement in terms of the timing involved and the resources. So I would think that there would be a lot of opportunities, and I'm surprised it hasn't happened again, frankly, so far.
I think, if we came across one that, I'm not against it. In fact, I'm actively would seek another situation where we can use that. But, a lot of times parties will agree and put it behind them and move on. In that case, there was I think a reasonable disagreement between reasonable people of whether or not it applied. And that's all you can ask for, because, reasonable people can disagree here.
We got into this part because you said you're rethinking your position about specialized tribunals, something that actually Josh and I are going to revisit in the chapter of a book that Global Antitrust Institute is putting out on digital markets. And the arbitration is sort of in a specialized tribunal, of course, and when you choose Kevin Arquette to do it. I've seen a lot of wisdom in other jurisdictions, for instance, China, but elsewhere as well, of having a tribunal that deals with both competition and intellectual property issues in the same side. So in the Chinese system, from the first instance court all the way to the People's Supreme Court, there is a chamber in each level devoted to IP and antitrust. And so often, an antitrust case elicits an IP counterclaim and vice versa, that it has a certain intuitive appeal to put these together when you have a court that's dealing just with intellectual property, such as our Federal Circuit. There's a lot of potential for downgrading the importance of competition as opposed to protection of intellectual property, and vice versa, for just an antitrust court. What would you think about combining those two, either by adding antitrust jurisdiction to the Federal Circuit, or by, I would hope, having a tribunal in which, as I've outlined, generalist judges would be available to hear those cases as a special tribunal as needed?
That's an interesting one. I had not thought about the Federal Circuit expanding its jurisdiction beyond patents and IP to include competition. I think they would benefit both from that and how they apply some of their rules for competition, for patents, to have that competition training as well. I'd like to think more about that, but I could see the benefit of it, because they have to deal with, the law and economics and competition policy as they're interpreting the rules and the statutes that they currently do. But that's a positive. But as you mentioned, I think in your paper of having a kind of a roving specialized tribunal of trained jurists that have some qualifying training that can play that role in a repeat transaction has a lot of benefit. And I think some of the judges would very much appreciate that, because sometimes, and I've heard this from judges, you're a district court judge, you have 30 lawyers from the Justice Department, 500 lawyers from some of the big deep-pocketed companies who are being challenged. They have a gazillion, Nobel laureates in economics, And here's a judge who may have never had an antitrust case, but is now reviewing a major transaction, who has, he's, I'm sure, incredibly brilliant, with 3 brand new lawyers who are also very brilliant, who don't have any experience in the real world. And now they're, here you go, Judge. You determine the fate of this whole industry for the future now with this transaction. It's a bit unfair, but it's something that they deal with on a day-to-day basis. But I think if there was a way to help not only give them the proper training, but tools through a way where you have, a certain selected, whether it's like a FISA court or some other mechanism, I really think it's time for us to take that next step, look at that, and do something about it. But the concept of putting that into the IP court is interesting. I had not thought about that, but I think there could be some merit about that. I'd like to think about what the downsides are.
Mm-hmm. Yeah. Well, this deserves more thought and attention. I hope it gets it. I'd like to see somebody do a serious study of how the Competition Appeals Tribunal has functioned in the United Kingdom, which has a very good reputation. Yeah. And now the system modeled on that in Canada as well. For a short time, India had it, but then they abolished, rejiggered their system. But experience in Canada and the UK would be readily determinable. We could study that and see how it would look. Now, they didn't combine the IP, but at least to give us some insight into the specialized tribunal. Last, if I can detain you for a few more moments, I'd like to this follows on from specialization to some degree. In this series of discussions, I've talked with Thibault Schreppel, who has been writing a lot about blockchain in antitrust and about the issues that will have started to arise for antitrust tribunals and enforcers arising from the use of blockchains in a variety of different settings. The technology is new and strange. I just finished reading a book about it. It's not impenetrable to the layman, but it's still a bit elusive. I don't know if the division has had experience with this or is girding for it. Have you seen it, or are you preparing for it? It's coming.
It's interesting. So I learned of your interview with a great professor, and I saw an article that he had recently written. It's on my next to-do list. It is important. Well, so just like economics, I think it's critical to understand. You don't need to be the expert, economist with a PhD, like my friends Professor Carlton and Shapiro and others, to be able to hear a debate about this as a judge. But you should understand some basic concepts of law and economics. Which direction is a supply and demand curve, and maybe some understanding of regression analysis and margin analysis. But I think having some basic understandings is really important on looking at how you apply the law to what the future business and transaction that's before you. I think in our business, what we're seeing is that blockchain, artificial intelligence, machine learning are key elements of business operations. That's not just the businesses in the online platforms and others, and self-driving cars. It is in the processes of current businesses. It could be the company that's manufacturing paper towels is using some of these techniques as part of their business or pricing strategies. So algorithms, that would be used through some of the machine learning mechanisms. I think it has two real impacts in the real world of where it interfaces with competition. One is on the more clandestine area is how algorithms could be used to test pricing. And you could create a very efficient cartel without having that policing and have prices stabilize without really having the critical element of that agreement, but with a real understanding, and you could engage in price signaling in a much more effective way. That's a real issue that at the last ICN I raised with a number of other enforcers that we need to look at and look at its impact on prices and on competition. And I don't think anybody has any readily available answers, but it's something where more and more companies will be using that, whether it's to set rates for apartment buildings or whether it's to, for widgets that are sold online. That's important. On the other side, I think blockchain has a real ability by decreasing the cost of verification. So one of the biggest uses we're seeing is really more in the financial technology field with things like Coinbase and Bitcoin and other, and it has huge abilities to lower barriers for movement of funds across borders and all that. And so I think we're going to see more and more of that. And it also has the ability to lower the cost of networking. And with those two elements, it's interesting because it'll have competitive effects to current incumbents that are positive. So we want to make sure that because of I think the prominence of blockchain technology that will occur, one of the things we have done is I implemented a pilot program last October where we put, I believe, 12 attorneys and economists through a program through MIT Sloan on, it's a 6-7 week online course. And we took volunteers at the cost of the division for folks to go through that at their own time. And then we interviewed folks and saw what was beneficial. And then we've done it now. We're about to embark on the third round of attorneys and economists going through that program so that they would have at least some fluency with the concepts of blockchain technology in various businesses and think about its competitive effect.
That's great. I'm very glad to know that. A long time ago when I was at the division, it was necessary to have a staff that was extremely knowledgeable, thoroughly conversant with telecommunications and how that sector of the economy worked. It was utterly essential. Not everybody had to know about it, but we had 6 or 7 people all the time who were very, very expert, really, and could deal with the lawyers from those companies as equals. That's very important. If I can prevail, I think, for one more topic, however, briefly, it's about the change in policy, again, an innovation from your administration on the credit for compliance programs, something that I've long advocated. I thought that the department was really, the division was not only out of step with the criminal division, but with logic to simply say, well, if there was an infringement, then obviously the program was inadequate. You don't get any credit. And then ironically, you say, well, if you if you didn't have a program, you had an infringement, but then you quickly scurry to make up the deficiency, then you get credit for it, which was, I thought, bizarre. So I very much welcome the current situation. I noticed that the criminal division issuance that just came out, the third iteration on compliance credit, now deals with M&A. So I take it, I infer that the division has had its say now within the department and that the current release reflects the division's policy as well.
They do. And it is, we held, when I first came in, we held a number of these roundtables where we got diverse views on that. And I agree with you. In my experience, I thought that it was, I understood some of the logic behind the argument that, you want to maximize the very successful leniency program that we have for, discovering cartels and offering any kind of credit at the charging stage for compliance might lessen the incentive for the company to run in. But the counter argument was you might also discourage from good compliance programs and self-reporting where companies begin gaming, statute of limitations and the costs of, of reporting versus not, whether or not leniency may be available if they did. So we heard from a number of folks in academia and the bar, and I thought it was time to change that policy. So we issued the guidance. And it's, if you have an effective, and we'll analyze it, we provided some factors consistent with the criminal division's policies. If you have a robust compliance program, you would be able to escape with a deferred prosecution agreement. Even would be even, if you don't qualify for leniency in that situation. And what the hope, as a matter of policy, was you would include that, and you would prevent this type of, anti-competitive conduct by, lower level salespeople or others, and encourage maximum compliance. Prevent it in the first place, rather than, I've said once, I think some people took it, in the wrong way, but I said, the best situation would be for us to never have to prosecute a case, rather than be constantly trying to identify hidden cartel activity that's going out there. And frankly, as successful as we are, I don't know how much we're actually uncovering. So we want to encourage good corporate citizens. And I think most companies who have a long-term view of their existence would like to comply with the laws and have the maximum incentive. And so we have been pleasantly surprised with the positive impact. And we're also seeing a lot more companies initiating and implementing compliance programs, which I think is ultimately good for everybody involved.
Well, I couldn't agree more. I'm really glad to see it. This release, I think, was just June 1st, just 2 weeks ago, if I recall correctly.
Well, the new release, that was the criminal division's update, where they, I think, harmonized their policy with some of the learning from our experiences in that. So.
Well, I know with respect to mergers and acquisitions, it says we're going to look at your compliance program at the time that the infringement occurred, and again at the time of sentencing, which I think is very clever, really. That makes a lot of good sense. There were a lot of sensible things in there about self-auditing and ongoing compliance and access for employees who are whistleblowers to contact an independent third party, all of that, all to the good, I'm sure.
Yeah, and on that point, there's legislation that has passed the Senate unanimously, but has stalled in the House somehow last couple of years, that we, as a matter of administrative policy, have supported, which is to provide whistleblower protection for antitrust violations that are disclosed, which doesn't exist in the law currently, but it would bring it into compliance with other areas of the law for antitrust. So I think it would be a positive change in our laws, and I hope it's something that's made perhaps this year.
Well, it's failed 3 times in 3 successive Congresses in the House. I don't know what the politics of it are. There's a GAO report on the subject, which is, of course, essentially neutral, but it gives a lot of the considerations on both sides of that issue. And I think it's something, I agree with you, it's something that needs to be done. And our peer countries have been doing it too. Mika, thank you so much. You've really been very generous with your time. We know you have people waiting for you for yet another meeting. So I can't thank you enough, and wish you the best of good fortune as you come across the 3-year marker very soon.
Thank you so much, Judge. Very much appreciate what you have done for the field of antitrust and continue to do, and particularly through the Global Antitrust Institute. And thanks for the opportunity to chat with you in this event today.
Thank you, Mike. I look forward to seeing you when this is all over and the pandemic is behind us.
Likewise.
Bye-bye.
Bye-bye. Stay safe.